All right, so Ann Taylor dropped a lot of documents on challenging the death penalty, which I would expect would have happened because she's also challenging all of the aggravators that were added on. So there are so many documents that I'm not going to do this all in one video. So I'm going to break them down. So I'm going to try to address the first 5 filings tonight. And then tomorrow I'll try to do the next 5 and so on. So let's get started. Okay, so the first filing is the expert witness disclosure. And the first one is Barbara Wolf, MD, from Leesburg, Florida. And Dr. Wolf is going to testify on the defendant's motion to strike the state's notice of intent to seek the death penalty on grounds of vagueness and balancing aggravators and mitigators. And then Eliza Pleener-Cover, who is a University of Idaho College of Law professor, is going to testify about narrowing death eligibility in Idaho. Like, she's written an article on that. And I will discuss a little bit about what both of those are that they're going to be discussing. And the rest of the pages on these are their CVs, their curriculum vitae. So I didn't think we needed to go through most of that. Although I will show you the first page of each one of them. So you can see that Barbara C. Wolf is an MD. She went to medical school at Boston University, and she's a pathologist. And then here is her licensure. She's licensed in Florida, New York, and New Jersey, and Massachusetts, and certifications on all these boards of pathology. She's also been a medical examiner. And then here is Eliza Pleener-Cover's CV, and she went to Yale Law School. She also got her bachelor's degree from there as well, not just her Juris Doctorate. Now, the article that the law professor from University of Idaho wrote, Narrowing Death Eligibility in Idaho, an empirical and constitutional analysis, talks about findings of an empirical study designed to evaluate how effectively Idaho's capital punishment scheme serves this constitutional narrowing requirement in practice. The study involved a review of first and second degree murder convictions in cases filed from June 2002 through the end of 2019 to determine how many of these cases would have been factually eligible for the death penalty under the terms of Idaho's statutes, regardless of whether they were pursued as capital cases by the prosecution. This review revealed that 86 to 90% of all murder convictions were factually first-degree murder cases, and 93 to 98% of factual first-degree murder cases were eligible for the death penalty. These findings strongly suggest that Idaho's statute fails to fulfill the constitutional narrowing requirement. The study also produced results on how frequently the death penalty is sought and imposed in death-eligible cases in Idaho. The prosecution filed a notice of intent to seek the death penalty in 21% of factually death-eligible cases. The prosecution proceeded to a capital trial in 5% of death-eligible cases, and the death sentence was obtained in 3% of death-eligible cases. These findings, which combine a high rate of death eligibility with a low rate of death charging and death sentencing, seem to suggest that death is an unusual punishment in Idaho, with important implications for its constitutionality under Furman versus Georgia. So what Alina Cover is trying to argue is that Idaho does not narrow down based on the Constitution how they apply the death penalty. But yet she almost seems to be contradicting herself, because then that next paragraph about her article was that Idaho's made it rare. So which is it? Are they applying it a lot because they're not narrowing it down, or is it rare? So it's going to be interesting to see what she argues as an expert witness, because I'm confused. Is she trying to get it struck down because it's rarely used now in Idaho? Or is she trying to get it struck down because it's not being used, like narrowed down enough? Now, she mentioned Furman versus Georgia, and I think it's important to bring a little of that background up. So let's take a look. Okay, so she cites Furman versus Georgia. And this was the case that basically stopped the death penalty in the United States for 4 years. They call it a landmark case. The Supreme Court decided that arbitrary and inconsistent imposition of the death penalty violates the 8th and 14th Amendments and constitutes cruel and unusual punishment. So they didn't rule that the death penalty was unconstitutional, but it did invalidate the death sentences of nearly 700 people. And it says the decision mandated a degree of consistency in the application of the death penalty. Dozens of states rewrote their death penalty laws, and most were upheld in Gregg versus Georgia in 1976. And then right after that, Utah was the first state to start up the death penalty again, and then slowly other states, including Idaho, followed suit again. So I find it interesting that she's citing Furman, because it's basically been invalidated now because of the states rewriting their laws. So I'm going to be really curious to hear what she has to say in the hearing in November, because I feel like her paper kind of contradicts itself, because if Idaho isn't narrow, then why have they rarely used the death penalty over the last 20 years? And then she's citing Furman, which has basically been invalidated by Gregg versus Georgia. Now, the Gregg versus Georgia decision did set forth two main features that capital sentencing has to employ in order to comply with the 8th Amendment. So remember, 8th Amendment's cruel and unusual. So there's two features, and these are the two. First, the state's death penalty scheme must provide objective criteria to direct and limit the death sentencing discretion. The objectiveness of these criteria must in turn be ensured by appellate review of all death sentences. And second, the scheme must allow the sentencer, whether the judge or jury, to take into account the character and record of an individual defendant. So it sounds like she's going to try to challenge that Idaho is meeting those two criteria for the death penalty. So she's trying to say that they're not, like I said, not being narrow enough. So, but we'll see. I still feel she's contradictory. Now, the other person, Dr. Wolf, is talking about balancing the aggravators and mitigators. And I found a case that it kind of explains what this is about. Because aggravators are what you add on to a charge to make it eligible for a longer sentence or for a death penalty. So like when you'll see that a gun enhancement has been added on. With murder cases, they can add on aggravators like burglary, like whether it was more heinous than other crimes. How many people were murdered is an aggravator, for instance. And then mitigators, of course, would be things like something to do with the perpetrator's mental state, things like that. So let's take a look. Okay, so here's a case that's an example of aggravating and mitigating circumstances during sentencing. So a jury found McKinney guilty of 2 counts of first-degree murder. The judge weighed the aggravating and mitigating circumstances and sentenced McKinney to death. Nearly 20 years later, the Ninth Circuit held on a habeas review that the Arizona courts violated Supreme Court precedents by failing to properly consider as relevant mitigating evidence McKinney's post-traumatic stress disorder. On return to the Arizona Supreme Court, McKinney argued that he was entitled to a jury resentencing, but the court reweighed aggravating and mitigating circumstances as permitted by Clemens and upheld both death sentences. So he still ended up with the same sentence, but they had to re-review it and take into consideration his post-traumatic stress disorder. So it sounds like Dr. Wolf is basically going to be there to argue that there's something that Brian has, or somebody in his family tree has, that could be a mitigating factor against the death penalty. So a mental illness or other factor. Now remember, they've mentioned before that for mitigation, it goes back 3 generations. So they would be looking back 3 generations of his family. And it could be not just a illness, but it could be, was there signs of abuse, child abuse, in any of those 3 generations. So it'll be interesting to see what she testifies to about that. Now let's look at the next filing. Okay, motion and memorandum in support of motion to trifurcate the proceedings and apply rules of evidence during the eligibility phase. It says proceeding with a bifurcated trial, which non-statutory aggravation is presented without the rules of evidence being applied, will result in a violation of Mr. Koberger's state and federal constitutional rights, including the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 1, Section 6 and 13 of the Idaho Constitution. So what she's saying is that Idaho uses a bifurcated system where it's the guilt phase and the penalty phase. So the trial and then the sentencing. But she believes it needs to be a trifurcated phase where they have the guilt phase, then a phase of eligibility to determine if the aggravating factors show that the defendant is eligible for the death penalty, then the sentencing phase. So I'm going to kind of skim over this and you can pause and read the highlighted sections, but she's talking about these 2 determinations that she believes should be split up. So whether the defendant is eligible for the death penalty and what the appropriate punishment is. So she's saying that combining these 2 are a violation of constitutional rights. And again, you can pause and read, but this starts talking about statutory aggravating factors and then non-statutory aggravating factors. And as you continue to read, you'll see that non-statutory factors would include victim impact statements and statements about the defendant's life and things in their past. So then it talks about how there's 5 different statutory aggravators. That's what the state has included to show that the death penalty should be the sentence. And it says that Mr. Koberger anticipates that the state will attempt to introduce substantial evidence of aggravation, which is not related to any statutory aggravator, including evidence about his past and evidence of his character. The state will also seek to introduce non-statutory aggravation evidence in the form of victim impact evidence. And you can pause and read this page. It just discusses more, again, about the non-statutory aggravators. And then this, again, talks about the constitutionality of a bifurcated model, and saying that an eligibility phase is akin to a guilt phase, and that the state bears the burden of presenting evidence supporting each statutory aggravator it seeks to prove. It's saying evidence that a court would never admit at trial, such as victim impact statements, hearsay, and character evidence, are allowed during the sentencing phase. And she's saying that that needs to be put during this eligibility phase that should be added. And this was talking about firearm enhancements and how the judge gets to decide on whether to add that on into the sentencing. And it says under a trifurcated model, only after the jury decides eligibility does it move on to the sentencing phase. So then it makes it harder for a judge to just say, well, there's this aggravator, so I'm going to add this on as the sentence. And she again brings up about what's admitted under a bifurcated system, saying the bulk of evidence in the sentencing is admitted without rules of evidence. So she's wanting evidentiary rules to apply by having that third phase. And you can pause and read this page because that's some more again about bifurcated versus trifurcated. And then it talks about the right to confrontation applies during the guilt and eligibility phases of a trial. So the Fourth Circuit Court of Appeals. So she's basically saying that, yes, he has the right to confront his accuser during the guilt phase, so he should also have that in the sentencing, meaning they need the eligibility phase in order for him to be able to do that. This is another page you can pause and read. I also didn't highlight anything on here either, but you can pause and read through this because there's some more case law on confrontation and an eligibility phase. And then here's the conclusion. Trifurcation of the proceedings is necessary to protect Mr. Koberger's state and federal constitutional rights. Mr. Koberger respectfully requests that this court grant the motion to trifurcate the proceedings into guilt, eligibility, and sentencing phase. Mr. Koberger also asks for this court to apply the rules of evidence to the guilt and eligibility phases. So in a nutshell, she's wanting to split the case into 3 phases. So the guilt phase, an eligibility phase, and a penalty phase, instead of just right now the guilt phase and the penalty phase. Basically, she's trying to challenge Idaho's system. And so if the judge doesn't want to split it, then she's going to try to say during the automatic appeal process, if he's found guilty, that his rights were violated because it wasn't trifurcated. So, and she's doing what a defense attorney does. This is a whole lot of spaghetti being thrown at the wall, and you're going to see what slides down and doesn't stick, and then you're going to see what sticks. So let's go on to the next filing. So let's go into the next one. This filing is motion to strike felony murder aggravator. So it says, comes now Brian Koberger by and through his attorneys of record and hereby moves to strike the felony murder aggravator from the state's notice pursuant to Idaho Code 194004A. This motion is made on the grounds that a malice of forethought murder cannot be aggravated by a burglary that itself is predicated in the same manner. So it says the issues are whether a felony murder can be predicated on a burglary itself predicated on murder, and whether malice of forethought murder can be aggravated by a burglary predicated on the same murder. It says felony murder cannot be predicated on a burglary predicated on murder. Okay. It is impossible to charge felony murder on the basis of a burglary with the intent to commit the murder in question. The state has given notice that it intends to show the murders in this case were aggravated because the murder was committed in the perpetration or attempted perpetration of a burglary, and the defendant killed and intended a killing or acted with reckless indifference to human life. In count 1, the state charges that Mr. Koberger committed burglary by entering the residence, located at 1122 King, with the intent to commit the felony crime of murder. Counts 2 through 5 all charge premeditated murder. In other words, the state seeks to prove the aggravated circumstance of this murder by showing intent to commit murder at the time of entry. There is no rational reason for a first-degree intentional murder to be enhanced by the fact that the murderer intended the killing at the time he or she entered the building. So basically they're saying that this is kind of like piling on. That the burglary charge was put on there to show intent of premeditation, to show premeditation, and therefore it should not be an aggravating factor because they already have the aggravating factors of premeditated murder on the other charges. Goes on to talk about case law. A person that burglarized a home with the intent of murdering Mason. The murder was not committed to carry out the commission of the burglary. Had his purpose been to steal jewelry and Mason was killed to facilitate his thievery, a case for felony murder would exist. However, the sole purpose of the burglary was to murder his victim. Just so happened she was in a place he was not permitted to enter. Thus, the murder, although in the course of the burglary, was not carried out in furtherance of it. So it says, thus, under Idaho law, a felony murder could not be based upon a burglary whose sole aim is murder. If that is so, the question is whether a deliberate intentional murder with malice aforethought can be aggravated by a burglary predicated on the murder itself. Then now we have the second issue. Malice aforethought murder cannot be aggravated by a burglary predicated on the same murder. And New York Court of Appeals has held that it cannot. The court considered whether a man charged with killing his wife's murderer, I think they meant his wife's murderer, could be aggravated because he entered his home to do it. The court noted that to reach capital murder, a murder must be intentional and having an aggravating factor. The court then found that the situation where the burglary is predicated on the murder intended is not adding anything to the murder. So basically saying if you intended to murder, it doesn't matter where you did it. So that you entered a home that you weren't allowed to be in is not an aggravating factor. Because murder itself, premeditated murder itself, the premeditated part's the aggravating factor. And then their conclusion states, based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant the motion that the felony murder aggravator in the state's notice pursuant to Code 184004A be struck, and the court not instruct the jury on the felony murder aggravator. Okay, so this filing actually goes hand in hand with the last one about the aggravating circumstances, and it's motion for court order requiring the state to provide notice of every alleged non-statutory aggravating fact, circumstance it may rely on at any sentencing trial, and to provide beyond a reasonable doubt every alleged non-statutory aggravating fact or circumstance. So they're saying that the prosecution needs to provide them with every victim impact statement, anything they're going to use about Kohberger's character or his past, just anything they'll use as a non-statutory aggravating factor, and that they need to be able to prove beyond a reasonable doubt those aggravating factors, which goes hand in hand with them wanting it trifurcated. And it talks about notice of non-statutory aggravated facts and circumstances, and that's citing State versus Hall, that the court held for the first time that evidence of non-statutory aggravating circumstances is admissible in capital sentencing processes. Mr. Kohberger has argued elsewhere that Idaho's capital sentencing scheme, as articulated in Hall, is unconstitutional due to its arbitrary nature. And that went back to the last filing we already talked about. Now, you can pause and read, but this is a case law that's cited here. And it was a person that was charged with 2 counts of first-degree murder. And it talked about how death penalty had not been recommended and had not been discussed. So despite the fact that the death penalty was not discussed by either party, at the conclusion of the sentencing hearing, the trial judge sentenced Langford to death based on inter alia on 5 specific aggravating circumstances. So basically the judge decided to go ahead and use aggravating circumstances to sentence him, even though the death penalty hadn't been discussed and they hadn't proven like these aggravating circumstances beyond a reasonable doubt. It says failure to require the prosecution to provide the defense with sufficient notice of any evidence of non-statutory aggravating factors, circumstances it intends to introduce at the sentencing phase would be a blatant violation of Mr. Kohberger's 8th and 14th Amendment rights under Langford and Gardner, as well as his rights under Article I, Sections 6 and 13 of the Idaho Constitution. Failure to require the state to provide such notice to Mr. Kohberger and his defense counsel would also violate the 6th Amendment and Article 2, Section 13 of the Idaho Constitution, because counsel cannot effectively engage in the adversarial process without pretrial access to such information. So they are asking for all of this to be given to them actually pre-trial. So not just if he were to be found guilty to then be introduced before the sentencing phase. And another section you can pause and read. Pause and read, talking about some more case law. And then I highlighted here that they're saying, for all the reasons set forth above, the prosecution must be required to give Mr. Koberger notice of any and all non-statutory aggravating facts and circumstances that it intends to introduce and or rely on at sentencing trial should one be held. Then it goes on to the next section, burden of proof. So in addition to requiring the prosecution to provide sufficient pretrial notice of non-statutory aggravating facts or circumstances, the court must require the state to prove beyond a reasonable doubt any non-statutory fact or circumstance it is permitted to introduce against Mr. Koberger. Failure to do so would violate the due process and the cruel and unusual punishment clauses of the United States and Colorado Constitution. U.S. Constitution amends, blah, blah, blah. I'm not sure why. I think they meant Idaho. Somebody messed up there because it would be the Idaho prosecution or Constitution, not Colorado. Then here's another page you can pause and read. And then I highlighted that unless the standard of beyond a reasonable doubt is applied to any non-statutory aggravating circumstances, the resulting process in any decisions in favor of a death sentence will lack the fairness and reliability required by due process and cruel and unusual punishment clauses of the United States Constitution. So they're saying that the jury will need to decide whether it goes beyond a reasonable doubt for him to get the death penalty based on non-statutory aggravators. So those victim impact statements, things about Koberger's character, etc. And the conclusion says, based upon the foregoing, an argument to be presented at the hearing hereon, this court is respectfully requested to grant the motion that A, the state's notice of intent to seek death penalty be required to list any non-statutory aggravators the state wishes to present, and the state be required to prove any aggravators beyond a reasonable doubt. Okay, I'm heading into the last of the 5 filings I'm covering in this video, so if you need to go get a drink of water, grab a shot of whiskey, do whatever you need to do, go ahead, pause, and come back. Okay, the last one I'm going over tonight is motion to strike future dangerousness aggravator. So it says the state's aggravator should be struck because it fails to genuinely narrow the class of defendants eligible for death and provides no standards to the jury to avoid imposing the death penalty in an arbitrary and capricious manner. So there's 3 issues on this one. In using Idaho code. So 1925-15-9I fails to narrow the class of death eligible defendants. 1925-15-9I is impermissibly vague. And 1925-15-9I, so all the same code here, irrelevant to culpability and therefore cannot be an aggravator. So they're basically saying that taking into consideration whether you think this person might go out and murder again or might be dangerous should not be an aggravator, should not be a factor for adding the death penalty. So it says to pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. That was in a case called Lowenfield versus Phelps. So again, we're back to talking about the narrowing. That was where the lawyer from University of Idaho that's going to testify as an expert witness was talking about whether they've narrowed the use of the death penalty enough or not in Idaho to certain groups. So they're talking about State versus Hall again. That case keeps getting brought up. But it says aggravating circumstances must meet 2 requirements. The circumstance may not apply to every defendant convicted of murder. It must apply only to a subclass of defendants convicted of murder. Genuine narrowing. And the circumstance must not be unconstitutionally vague. And you can pause and read about this different case law about vagueness. Now, this all ties back to the two expert witnesses. And it brings up some more case law, and it says both holdings are problematic within the jurisprudence outlined above. And it says Idaho Supreme Court's definition of propensity to commit murder matches and even makes use of the language from the definition of murder. Essentially, the court excluded manslaughter. And it says the United States Supreme Court failed to recognize that the vagueness inherent in the question of whether a particular individual poses a threat to society is that the very factors that might lead one person to conclude they should die may be brought out by another person as a reason for mercy. So they're saying that the Idaho Code fails to narrow the class of death-eligible defendants. And you can pause and read because here's some more case law. But they're basically kind of talking about if the person's got a mental illness and you think they're going to kill again because of that mental issue, that they should possibly get mercy instead of the death penalty. And then they go into their next part about it's impermissibly vague, because they're saying that future dangerousness was not vague as it was something judges had to do all the time. While this is true, vagueness of future dangerousness does not lie in what concept means, but what a jury is intended to do with the information. Traditionally, future dangerousness was seen as mental illness, which in turn was seen as a mitigating circumstance. The Supreme Court confusingly also held to this traditional understanding in reversing death penalty cases. Is evidence of future dangerousness both an aggravating and mitigating factor? If it is, then how can this evidence be adequate to inform jurors what they must find to impose the death penalty, and as a result leaves them in appellate courts with the kind of open-ended discretion held invalid in Furman versus Georgia? Hey, we're circling all back to Furman versus Georgia, which again was basically invalidated by states rewriting their laws. But she's going to use both of those expert witnesses to argue that Idaho law is not narrow enough and is too vague. And then I'm really getting the impression, that they're going to try to say Kohberger has a mental illness. Because having this MD testify and then bringing this future dangerousness up and saying that mental illness should be a factor for mercy. And then you also had that other filing about the mitigators versus aggravators. I feel like they're heading there. Now, obviously, Idaho does not have an insanity plea, but you can get the death penalty taken off the table if you can show that the person has certain medical conditions, mental factors. Part of why Lori Vallows was taken off the table was because of her mental state. And this is another page you can pause and read, talking some more about mental illnesses and aggravators. And then their third issue they brought up was stating that Idaho Code is irrelevant to culpability and thus cannot be an aggravator. More concerning from a constitutional standpoint is that the United States Supreme Court has never actually held that evidence of future dangerousness is relevant to whether someone should die. The Eighth Amendment requires that defendants only be condemned to death if they are deserving of the ultimate punishment based on culpability, not their dangerousness. So basically they're saying that if you're going to sentence him to death, it needs to be based on the crime he committed and not anything he might do in the future. And then you can read, there's some more case law information on this page, so pause and read. And then the conclusion says, based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the future dangerousness aggravator in the state's notice pursuant to Idaho Code 184004A be struck, and the court not instruct the jury on future dangerousness. And then there's also an appendix that was added on this is just the first page of it, but it goes on for several pages, that says overview of task force proposal on mental disability and the death penalty. Okay, so hopefully I didn't confuse anyone too much, and if you have any questions, let me know. As you can see, a lot of these filings all tie together, and that's why those two expert witnesses are being called, because they're going to talk about a lot of these things that tie together. But it's interesting. She's trying to get these aggravators thrown out a little at a time to chip away at saying, well, yeah, even if it was capital murder, it shouldn't be the death penalty. But I'm finding these mental arguments really interesting, because it's making me wonder now what she's going to use as mitigation. So I will try to discuss the next 5 filings tomorrow night, and y'all take care.